Today, I'm speaking with DePaul alumni and former immigration judge, Carla Espinoza.
I did my JD at DePaul Law, and while I was there, I did a lot of human rights work, international human rights law, and I also transitioned into immigration law, and I continued on that path. All of that in private practice. I became a managing partner for my previous law firm before I was appointed as an immigration judge back in July 2023. I'll explain what I started to observe from the beginning of the year until recently. So obviously, the Chicago Immigration Court had a lot of cases, a lot of work. We'd be short-staffed for some time, but we were starting to catch up. Things changed drastically starting in January, specifically after Inauguration Day. That same day, Inauguration Day, 4 judges at the leadership of the immigration courts and the Executive Office for Immigration Review, EOIR, were removed from their positions by email. And they all had been with the agency for decades. A complete removal from their position in such a manner for a career judge who has been on the bench and in public service for decades wasn't heard of. So it was concerning for all judges, obviously, and it changed the environment in the courts. In February, there was another round of removal of leadership judges. So those are the assistant chief immigration judges. Those judges oversee one specific court, sometimes 2, depending on geographic location. So again, that kept instilling some fear. Along with that occurring, we began to receive memos often, usually on Fridays, late afternoon. And the content of the memos was broad, but it certainly had a tone. The Chicago Immigration Court had been understaffed for such a long time, and all the clerks were working extra hard to make up for that lack of staffing, which makes what happens later even more inexplicable. Judges adjudicate a lot of cases over any other court, any other federal court, but also any other court that renders final decisions. Judges nationally adjudicate between 500 and 700 cases a year. My first fiscal year, I adjudicated over 1,000 cases. Then there was a memo. The messaging was, value your work. We're looking at targeting you, and we're likely going to target immigration judges. So, of course, that instilled a lot of fear. That changed the dynamic in the court. As a judge, that feels like pressure, like intimidation. I never, and my colleagues never succumbed to that pressure, but it doesn't mean that we did not feel it or were affected by it, and that it made our job significantly more difficult, because it did. Thereafter, there were changes. We received instructions not to get involved in enforcement by ICE officers starting to occur in immigration courts. Mind you that historically, there were agreements and understandings between DHS and EOIR and the Department of Justice that enforcement would not occur inside the courthouse. So historically, as judges, we've never seen that before, of enforcement happening inside a courthouse. And we were concerned, but we received instructions not to be involved with that. Thereafter, we received another email. The chief received another email that she was to disseminate to all other judges, essentially how to go about ruling on motions to dismiss and how to go about issuing oral decisions. So this email said 2 things. That judges, we could no longer or should no longer schedule oral decisions if we were not able to issue them the day of the hearing. This doesn't make sense if you're trying to be efficient, because oral decisions, the whole purpose of it is to be efficient. Writing a decision can take days. And so it was a tool that we had that was being taken away at a time when we understood we had to be more efficient. So the second part of that email talked about motions to dismiss. So by that time, we had received motions to dismiss cases by the Department of Homeland Security. Again, these are the prosecutors of immigration cases. They're saying that a case should be dismissed. If a judge grants a motion to dismiss, that means the case will no longer be in court, and so the person will no longer be under the jurisdiction and authority of the immigration judge. As a judge, I'm going to make sure the due process prevails, that there's a fair hearing, regardless of the result, but that the hearing itself and that the process itself is fair. When an individual is not in that process, then they don't have those protections, right? But it became clear to us that now it is going to be used so that individuals, respondents that were previously in immigration proceedings, could be placed in expedited removal proceedings, which are proceedings without those very protections. They expected for judges to do things differently. It's very concerning. Again, a lot of that backlog is also the result of the weakening of the courts, which has happened increasingly since the beginning of this year. If you want to address the backlog, obviously you want efficient judges adjudicating more cases. There had been a deficit of judges before. Again, a deficit in staffing. Since January, approximately 106 judges nationwide are no longer on the bench. That's a significant number of judges. And that certainly not helped the backlog. So my concern is that what is taking place is not meant to address the backlog in a fair and meaningful way, but rather that it has different motives. And that's concerning because this is a different situation. It's not about budget, although I'll say the new bill allows for an increased number of judges. It allows for up to 800 judges, right? Right now, I think we're around 600 judges nationwide. So there should be many more judges. But the reality is when you actually look at the bill and see how much budget was given to enforcement of immigration, to ICE, and to detention centers, there's a striking disparity between what was allocated for the courts. But there are billions allocated to detention centers and to enforcement. So that is not aimed at resolving the issue through the legal process and through the courts, but rather something else. Regardless of whether you care about immigration or don't, I think there's a broader concern that is important for people to understand, and that's due process and justice. When our institutions are being weakened, when there's no checks and balances, when there is no due process that affects everyone, right? Everyone within our country has a guarantee to due process. I personally took an oath to protect the Constitution, and that is why I like to talk about what is happening. As far as what individuals can do, I think it's important first to be aware, to be acquainted with the circumstances. I think speaking truth to power and talking about what is necessary to make sure that we have a proper legal construct and a working court system. The courts are there to protect the fairness of the process for the person appearing, but that may be anyone and anyone present in this country at any given time for any given reason. And the court may change, the judge may change, but the due process guarantee is the same. Obviously, because of the system now, litigation has changed. So I think for the community, especially resources are going to be needed for purposes of litigation. Communication is going to be key because now that individuals are being detained at higher rates across the country, that is going to require a different type of litigation in district court, habeas corpus, and that sometimes requires communications. An individual may be now detained in Texas or Louisiana, but their family may be in Illinois. So having those resources clearly said, those communication organizations, especially clinics, pro bono organizations, NGOs, grassroots organizations that have some resources or some context to other areas. Having those available is going to be key for attorneys trying to maybe litigate a case that started in Chicago but may not end in Chicago. And yet, I think it's important to have access to counsel so that they can have their rights, a meaningful hearing with fairness, whatever the result may be.